we are going to get started. Welcome to our meeting. We don't really want to waste a lot of time. Thank you for attending. Our colleagues will join us as the meeting progresses. So I will call Councillor Centurion to do the opening and welcome. And then probably they will be able to Mr. Tshwane who will do the presentation. Thank you.
Thank you, MC. Good evening, everybody. I'm Councillor in Australia. I'm the Councillor for 66, studying Councillor for this board where the Councillor sadly passed away. Of that, now I'm going to ask us to please just close our eyes for a few minutes, just in respect of our past Councillor. Thank you.
Yeah, maybe we should stand or maybe we should stand.
Still rest in peace. Thank you. Welcome to full of freedom and issues that the committee member for Region 4. Centurion is Region 4. We are divided into 7 regions in Tshwane. This is Region 4, Centurion region. So she's the MMC running the Region 4 for us. Welcome, Councillor Tshwane Wilson. I see you also here. I don't see any other councillors here, but welcome to everybody. Then I'm going to call Mr. Lesego. Let me just make sure that I've got his surname correct. Tshwane, he's the Deputy Director for Building Control in Region 4. He's going to tell us a little bit more of the draft bylaw that we tried to pass now. Thank you. Over to you, sir.
Good evening, ladies and gentlemen, the MMC councillors. I suppose all protocols I'm Tshwane, Deputy Director for Building Plans and Inspection Management in Region 4. Today I'm going to do this presentation on behalf of Build Environment and Enforcement. The department is for economic development and spatial planning. Division is built an environment and enforcement section is building plans and inspection management. Basically, we know this in other municipalities or regions, we know as building control. So only in Tshwane will be building plans and inspection management, but it's actually the same thing. Today I'm here to present the bylaw, the draft bylaw, which primarily is going to deal with problem buildings and properties within Region 4 and in particular within the jurisdiction of COT in all 7 regions of City of Tshwane. The bylaw primarily what it wants to achieve is to encourage a business-friendly city that encourages or promotes economic growth and creates jobs, caring city that supports the vulnerable and provides social relief, professional service and accountability and transparency. So basically, the background of this bylaw, what it's trying to achieve is that City of Tshwane, like many other cities around, whether it be Joburg or Ekurhuleni or wherever you go around South Africa, we are experiencing urban decay and degradation. Dilapidated and hijacked buildings everywhere, unoccupied and abandoned properties, unsafe properties, illegal connections, service connections. We know that we have a serious problem of illegal electricity connections and water connections everywhere. Illegal land use, where guys would use buildings or properties without the proper land use application. As we know, properties in terms of land development, it starts from land use, guys they don't usually apply for any rights, which then creates a problem for the municipality, because if one had to apply for the proper land use, obviously there's a process that must be followed in terms of LUMA land use application and management, where there are bulk services to be paid and so forth, which then makes it possible for council then to make provisions for services or allocate more services for the property in terms of, let's say for argument's sake, a property was zoned residential, one is going to be used as a commune or a business. The provision of service or allocation of services on that property would be more in order to cater for whatever that's to come. So with that proper land use, obviously, we experience water cuts and many other undesirable problems that we encounter. And obviously, as a result of improper or illegal land use, it creates a problem for property rates as well. Because obviously, with a rezoning application or a proper land use, your rates will be adjusted. So obviously, if these properties are used illegally, council doesn't get the money that it deserves. Provisions of services and so forth is not what it's supposed to be. So, ladies and gentlemen, this bylaw, it deals primarily with the state of affairs. The city has established IBEC. IBEC it stands for Integrated Bylaw Enforcement Committee. This IBEC, the Integrated Bylaw Enforcement Committee, this bylaw comes from, we used to have a bylaw called derelict buildings. But this derelict building bylaw was primarily about building control and land DCU, development compliance. So in terms of building control, there's very limitations, because from building control section, we're limited by the national building regulations. There's only so much that you can do to enforce the law, because it's very compressed on its own. Let's say, for argument's sake, a guy was dealing with, there was a waste problem. From building control, we wouldn't do much, because it's not covered in terms of the national building regulation. Or there was a health problem, there was food premises. Building control won't be able to deal with that in particular, because we deal specifically or mainly with buildings. DCU, development compliance, basically deals with land use contraventions. So they'll be able to issue a land use contravention where the property is used for something else other than what it was intended for. So it's limiting as well. So with this IBEC, this Integrated Bylaw Enforcement Committee, we're adding many other sections or departments, whether it be fire, it can be fire, health. Fire is there, health will be there, building control will be there, Metro Police will be there, DCU will be there, LUMA, guys who deal with town planning related applications and so forth. Because building control normally, it's from one property boundary to the next. So, we've got guys who are selling stuff on pavements and so forth. In terms of building control, we can't really issue a contravention for somebody who's selling on the road reserve. But with Metro Police forming part of this integrated bylaw enforcement committee, it kind of extends the reach. There's a lot more other departments that get involved in ensuring that there's compliance development-wise within the city of Tshwane. So basically the discussion or application of this bylaw, it's the provisions of this bylaw apply to all categories of buildings and properties within the jurisdictional geographical area of the municipality, including buildings and properties owned by the state. So that explains itself. Private owners, obviously, on this bylaw, it stipulates what is the responsibilities of property owners, whether be the state, whether be the private owner. I want to believe the state will include the municipality as well.
Apologies for that.
No, that's okay, Councillor. So basically, this bylaw, it will stipulate.
Sorry, when you try to mute, you can't mute.
Because I'm a bit scared, it buys me time to calm down a bit. I'm nervous.
I can't be nervous. This is such an intimate audience.
So in terms of the responsibilities of property owners, this proposed bylaw stipulates what exactly it is that the property owner is responsible for, despite of who the property owner is. I'll just quote a few as I go along, like to maintain the property in a good state of repair and in safe condition, notify the municipality of the condition of any building or property that is or has become dangerous to life or property, not permit it to be unlawfully occupied and used for criminal activities. We know that when it says not to be unlawfully occupied, that's where now we go back to that land use related applications where one must apply for the correct use whenever he wants to do. Especially in Tshwane now, we've got a problem with student accommodation. Guys would buy a normal residential one property and convert it into a commune. For you to do that, there's a process that one has to follow to change the land use from residential one to either residential two or a commune. With that comes bulk services contributions, allocation of services, and many other things. So if you don't follow that process, then you shortcut. Eventually you've got a property that doesn't comply, obviously, with the submission, with this bylaw, with fire department being involved, health department being involved. Fire will ensure that there's enough fire escapes. Health department will ensure if there were kitchens and whatever else for catering, kitchens, in terms of the Health Act, they comply. So from building control, we're only limited with the actual physical building. But this gives us an opportunity to ensure that everybody does that. For instance, not permit the dumping of waste. We know that we've got a problem of people dumping everywhere. So at least with this bylaw, it will give us an opportunity. Waste is going to be involved in ensuring that guys cannot dump wherever they can or wherever they see an empty piece of land. You can put in no illegal dumping, guys just do it. Because we know that there are no repercussions. So with this bylaw, it gives us at least a bit of something that we can do to enforce. With every action, basically there will be repercussions. Keep all buildings and property in a state of repair, meaning that maintenance of buildings is a serious problem, especially with buildings that belongs to the state. The maintenance, therefore, is not up to scratch, but this bylaw then would ensure that anybody and everybody who's concerned or who's affected can report that to IBEC, this integrated bylaw enforcement committee. Then IBEC will take action in ensuring that there's compliance in whichever way or form. Obviously, non-compliance, therefore, there's a penalty to it. There are consequences to it, whether it be legally and so forth. So, the next point would be the provisions of this bylaw apply to, this bylaw binds every owner and their successor in title, beneficial owner, and every occupier of a building or property, including the organ of state. I think I've already passed that. Basically, then explains the duties and responsibilities, ensuring that the building or property is not unlawfully occupied or used for criminal activities, owner must take the necessary measures to evict the occupants. If waste has been dumped or accumulated on the property, the owner must remove the waste and transport it to a licensed, designated disposal facility at the owner's cost. If any building or part of the building or structure on the property has become derelict, the owner must ensure that access to the building and or part of that building is prevented, take any steps necessary to secure the building or part of a building, and apply for the necessary demolition permit in terms of Section 12 of the Act. Because some of these buildings, as we know, or as we can see, or as we experience, they're dangerous because they, due to lack of maintenance, they're not occupiable. They're unsafe. And the very same purpose of building control or built environment and enforcement is to ensure the safety and the health of the occupants. But because it stretches a bit with this bad building and properties, this is not only limited to buildings or in terms of a house or an office block. It goes to an extent of property. Because we know that there are properties that have overgrown lawns and they're not taken care of. It extends beyond the physical building. It extends beyond, you can drive around and see that, but this area is overgrown. You can report it to IBEC so that something is done about that. So basically it encourages maintenance of development within the jurisdiction of Tshwane. Encourages property developers to come and invest within our city. We know if you want to invest anywhere, you want to ensure that your investment is well taken care of. You'll make profits out of it. So if the area is not taken care of, as we can see, even decay all over cities and so forth, it becomes difficult for developers to see the need to continue to develop or to continue to invest in such areas that are not taken care of. Liability of owners for damages and costs. In an instance where the owner has neglected his responsibilities in terms of either taking care of a building, maintaining the building, this bylaw proposes that council, after having given the owner either a contravention notice to comply, or be it a land use contravention because you've got a national building regulations contravention notice. Then you've got a land use scheme contravention notice. Surely you'll have a fire notice, you'll have a health notice, you've got many others. So that's why we're trying to combine all of these sections to fall under this act so that whichever contravention that comes up, it can be attended to within this committee that will be constituted by an authorized person. Will be obviously in this instance the authorized official is the municipal manager or somebody who's going to be appointed by him to execute that on his delegation. Basically it will be a sub-delegation. It will be sub-delegated by the municipal manager to perform his duties. In an instance where the owner doesn't do whatever that's supposed to be done, council can do it on the owner's behalf at council's costs, but do the repairs or mow the lawn or attend to the problem that exists, but council takes that money. After having done that, council takes the cost, puts it in the owner's municipal bills. So it's not for free. It's not for free. Council will attend to the problem, bill you. If you can't pay back, take that debt, haul it into your municipal service account. Obviously, I want to believe that there are some rates bylaws or act that's used to do that. I'm from city planning. I wouldn't be able to clarify beyond how that amount gets to be transferred to your rates. I can clearly explain how building control and city planning works. In an instance where the building is unsafe, obviously a contravention notice will be issued for evacuation or for the demolition of that building. Because obviously there's a time period that the owner will be given to attend to the problem, failure of which then council only at that point then takes responsibility to either fix the problem on behalf of the owner and charge him, or obviously it's court. Because council cannot order you to demolish any building in any case. That's something that's done by the court. We can issue with a contravention notice, we can take you to court, but at the end of the day, it's the decision of the court to order you to either demolish a building or not. But from our side, we have done what we're supposed to do. The rest lies elsewhere in our courts. Okay, investigation for non-compliance means anybody, either be it your neighbors or anybody in the jurisdiction of where you're staying, can report any bad building. In that instance, an authorized official has got the duty and authority to enter any building or property at a reasonable time to investigate, to determine non-compliance, and issue any contravention notices, should there be any contraventions. That is supported in terms of Section 15 of the National Building Regulations and Building Standard Act 103 of 1977. That actually has already been done by building control. In any case, the BCO has got the right to access any property, but within reasonable times. The building inspector cannot come, or the authorized official cannot come at night to come conduct inspections, obviously to be within the allowed time periods. An authorized official may be accompanied by any approved competent person as contemplated in Part 19 of the Act, who is instructed to examine the building and report on the state of the building and any measure to be taken. Let's say, for argument's sake, the building was an unsafe building, structurally unsound. A building inspector is not a trained structural engineer. It means a building inspector can ask a structural engineer to accompany him to further investigate or to further build up a case to declare that building unsafe. It takes more than one competent person to arrive at that determination, because obviously a structural engineer is a far much more competent person to determine the structural integrity of a building more than a building inspector. The building inspector can ensure compliance, whether in terms of the National Building Regulation, but that on its own is very limited on what it can do to determine non-compliance. Therefore, declaration of a problem building or property in the event of the failure of the owner to comply with the notice of compliance contemplated in Section 8, such notice shall be regarded as a notice of intention to declare a building or property or a problem property as specified in the notice. The authorized official may issue a notice of intention to declare the building or property to be a problem building. So if we go and check, for argument's sake, on our definitions of what, for instance, a problem building is, the bylaw or the proposed bylaw clearly, I hope, stipulates what that would be or is regarded as. A problem building and or property means a building or a property or both that has been declared under section to be a problem building or a derelict building or an unsafe building or a non-compliant building in terms of the National Building Regulations and Building Standard Act. So basically what this bylaw is trying to achieve is to ensure the safety and health of the occupants, to ensure that the environment, because we even have, I think, environmental management involved, to ensure that the Environmental Act is not being contravened. I'll make an example for argument's sake. We have a situation where a guy or a developer would purchase a property with an old house on it, obviously, and he'll apply to demolish that building. But that application is submitted at building control. Building control will only look at the building itself and ask for an engineer to sign for that building to be demolished, check the heritage status of the building. If the building is over 60 years, ask for heritage to comment on it. But what building control wouldn't do, or city planning wouldn't check the environmental factors that comes with that application. Then environmental management comes into play now, because they started coming into this problem, or into this trying to solve, helping us to solve the problem that exists, to say, building control, when you approve this demolition permit, you don't consider the environmental impact. There are trees that are protected by the Environmental Act. There's vegetation that's protected by the Environmental Act, which you don't take into cognizance. The guy just goes there, gets a TLB, demolish everything on the way, including those trees, and produces that permit to say that you have now issued a permit, I've got a permit to demolish, I demolished. But in that process, it doesn't only demolish the building, it demolishes everything else on his way. So with this type of bylaw, we're trying to come up with a way when a developer now submits, for instance, a demolition permit, that demolition permit is going to even submit what we call a landscape plan of what's existing on site. Environmental management is going to check which of these trees can be demolished or can be cut, and if you cut this, how many must you replace and where and how, so that they encourage the green. As we encourage development, we don't destroy all the other natural aspects that come with it. I hope you get where I'm going with this. Okay, thank you. So, an authorized official may issue a notice that I've said there's an evacuation, eviction, demolition, and expropriation. We know that the evacuation of a building only comes with unsafe buildings. If, for instance, I'll make an example, we had a situation just around the corner. As you all know, that those who are familiar with Region 4, we've got sinkholes everywhere. So in instances where the building is impacted by a sinkhole, or we think it won't be able to hold, it's no longer structured, the integrity of the structure is compromised. Evacuation of the occupants. As per the authorized official, the order will be given to the occupants to evacuate the building due to the unsafe. Because of the building is, the structural integrity is now unsafe. The building cannot be occupied. But then when it comes to the eviction, we've got problems where guys have now using buildings that don't have rights. Like I was saying, somebody bought a house, it's now being converted into a commune, which seems to be the trend these days, without proper land use. If there's any complaints within the area, IBEC would be able to deal with such. Because firstly, the developer will be using the building, making profit, not paying rates, without having applied for rights, having not paid bulk services contribution, and many other factors that impact that building. Council or the municipality has a right to apply for an eviction or to expropriate. There's an expropriation. But the Expropriation Act, the expropriation in this instance, it says to comply with the applicable law. Because you know that we have now introduced this expropriation of land, but it's still under review because there's other objections onto it. So that expropriation part would be guided by, remember this is a bylaw, we've got national law, your bylaw falls underneath it. So it cannot go outside of what the national law is saying. So obviously now we're waiting for whatever the judgments and the review of that Expropriation Act to see how best can this fall under that without necessarily going outside of what's prescribed in the law. Demolition, we already spoke about this. If the building cannot be salvaged for whatever reason, a demolition council can then issue a demolition permit in terms of Section 12 of the Act, order the owner or compel the owner to demolish an unsafe structure if the need arises. But obviously, that can only come after the structural engineer is ascertained that the building is unsafe. It's not something that's going to be thumbsucked. If the order is not obeyed, the municipality may apply to court. So this eviction and demolition expropriation, it's a process that will be guided by the court, like we've been doing with many other cases, where if there's any complaint or contravention, we give a contravention notice, the matter is referred to court, a court file is opened, the court decides, the municipal court. But usually if you go to municipal court, it sometimes fines. You pay a fine for admission of guilt and Not unless if you refer the matter to High Court, where a demolition can be, an order for demolition can be issued, or an order for expropriation would be issued in terms of whatever law that would be applicable at the time. Expropriation, the municipality may apply to court to expropriate a problem building or property if the owner fails to comply with the measures contemplated in Section 11.3 of this proposed bylaw, or if it is unlikely that the costs incurred by the municipality to try and correct the problem, the council will never be able to recover it from the owner. Saying if, for instance, you've caused so much damage or you've connected illegally, either be it electricity or water, for so long that you owe so much money to council that you are not able to pay that money back to council, then council, according to this bylaw, would be allowed to then expropriate their property, sell it, recover their losses, and pay you your difference after they've recovered their losses. Yeah. The municipality's infrastructure services are so affected, that's what I was talking about, or if the municipality infrastructure and services are so affected by the problem building or property as to warrant expropriation. We're talking about that electricity, legal connection, and water connections, and expropriation can be done, obviously, through the applicable legislation. So basically, that's about it in terms of what the synopsis of this is all about. There's a bylaw which goes deeper into detail on what is going to be done and how definitions of what it means. For instance, I'll just go a bit into the bylaw, chapter 3 of this. All that it does is to explain the duties, the responsibilities, and the liabilities of the owners. Chapter 4 speaks about the investigation or the inspections to be conducted to ascertain the legality of whatever that's taking place on site. Chapter 4 speaks about the duties of the owners and the measures that can be taken by council, liability of owners for damages and costs, ensuring compliance. So all that this actually is trying to say is that if you don't take care of your property as the property owner, if you act outside of legislation, whether be it national building regulations, whether be it LUMA or SPLUMA, whether in whichever way or form, council is going to be allowed, or the local authority in this instance, is going to be allowed to intervene, whether by trying to help you fix the problem and give you the debt and pay itself back, or in an instance where you say, no, because obviously this notice is, they said, we're giving you 14 days or 21 days to respond and give us time frames to say, within these 21 days, I would have responded to say, I'll attend to the problem. It's either if you want to do it all by yourself, it's okay. You do it, the building inspector or this IBEC will just go check if you have complied, and then it's okay. In an instance where you can't, that's where all the other liabilities then comes into play, either be it in a form of payment or in whichever way council decides or the court decides. Guys, you way too quiet.
No, we're going to take questions after your presentation.
Can we speak?
We are going to, once he has finished, I will take hands.
Okay, a round of questions, okay. Yeah, I think that's about it.
Okay, should I take hands for?
Yes, ma'am.
Okay, so thank you. And that the Tshwane. I'm going to take hands for questions. Okay, it will start, let's just everyone that wants to speak. So it will be 1, 2, 3, 4. Okay, so that will be the first round. Can that order?
Thank you. I just want to know, I haven't gone through the bylaw or anything.
Okay.
How will the municipal court's hand be strengthened? Is it addressed in this, in terms of timeframes, in terms of personnel, in terms of giving them teeth?
I want to.
No, we'll be here the whole night. So what we're going to do,
I'll take all the
note all the
questions.
questions. Yeah, you can actually sit here. So that you note all the questions, and then we'll take that first round, you'll respond, then there'll be an opportunity for you to come back if there's further clarity required. But I think the one thing I do want to add is that this bylaw, it comes at the back of the derelict building bylaw. Like he explained, it wasn't giving enough power. The mayor then started something called the Bad Buildings Committee, where we looked at buildings that were derelict, and we realized that there's a gap, and that is why we are bringing this bylaw to close that gap. So that is just the motivation behind us getting this document. But so you are next.
Thank you very much. Look, I have read the bylaw, and it's a very cumbersome process that a person must go through to eventually solve a problem. Because often a problem starts as a small problem and it becomes a very big problem very soon. Nothing's ever easy. And it's good that the city of Tshwane wants to resolve some of these problems, because I can give you an example. You know, our councillor passed away recently, and his house, he was a single man. Now, his house will probably go into his estate. An estate to get wrapped up would take in the order of 2 years, sometimes longer. So his building is going to become a problem building because there's no one to maintain it, no one to take care of it, there's no money to fix it. And it is inevitable that it will become a problem building. Maybe in his estate there's other means that he has provided for this event. But so there are many other problem areas where a person passes on, his family is left behind. Whatever they are left with is inadequate to maintain their accounts and to maintain the building and to maintain whatever goes with it. So, quite rightly so. If they cannot afford to stay there, then they shouldn't be staying there. So, the process that we are talking about here is going to, especially when you go to court, if you now hand over this problem building matter to the courts, I mean, a court case never takes less than 3 years, 4 years, you know, so the problem gets bigger and bigger, and eventually the poor family will end up with nothing. In fact, you said that the building will be sold and the bills will first be paid and then whatever is left over. There will be nothing left over. They will get nothing. They will be out on the street. So, I'm trying to get to the point where I'm not against the Bible. The Bible is good because there's time that we need to resolve many of these problem buildings. But somehow we need to make it a lot quicker and faster. I mean, to apply for land use change is a cumbersome process. It takes long. To have building plans approved takes long. Takes too long. Everything is slow. And the slow part is with those people working for the municipality. That is what takes a long time. But okay. I agree that the process is good. It's just going to take too long. And we're going, well, what happens in many of these buildings is that homeless people eventually invade the building. And the owner, you cannot find. He's overseas, or he has passed away, or the building is just there. Now, someone needs to sort it out. I mean, the sooner you can get to a point where there's a public auction to say, look, let someone take over this building, take over the maintenance, someone who is capable, and make the process a lot shorter for the people who is affected. I want to add my comments to the public participation, but I'm just not clear on how it can be made easier and quicker, because this comes with an enormous amount of emotional stress for a lot of people. So what I'm saying is we need to find a way to make it quick. If a problem is small and a inspector comes and says, listen sir, this tree here by you need to chop it down. Then he's given 7 days and it gets chopped down, and it costs him only 1,000 or 2,000 rand. But the longer it takes, the more expensive it gets, and eventually he loses his property because of a simple, small problem. We have to try and avoid that. Thanks.
Thank you. There was another hand, I think. Yes, it was you.
Thank you. First of all, thank you for the initiative and for taking the time. I have read through it, not in too much detail, but I will be written submissions as well. I'll start with the court process and the application for an administrator to be appointed. I'm really concerned about that. Firstly, do COT have the funds to take lawyers to get to court? Number one. Secondly, we have insolvent owners and derelict buildings. I'll get to that in our area. The timelines for the High Court, we're looking at here in Gauteng, 2031 is the first cases that are going to High Court. You know about the fighting directives. We've got mandatory mediation now, and I think that perhaps a way of linking into what the gentleman was saying was to perhaps include a mandatory mediation clause in this bylaw to get with the times and that we can move forward quicker. We do not have time, we don't have the money for going to court directly. Perhaps it would be something to explore, and I'd be happy to give you documentation in that regard. Then, with regards to the next thing is when we are looking for, I understand that this bylaw has been passed by council. Is it going to be enacted if we're waiting for the Expropriation Act judgments? We're going to be waiting a long time. I'm really concerned about that. And then also this links to the fourth slide that you have about the IBEC. The inner circle says that it's inner city task team. Is that the CBD? Because we're talking here about Ward 79 and Ward 57. So I'd like to know if it's only the inner city, the CBD, or does it include us on the surrounding areas? And then with regards to your privacy clause in Chapter 2, that's your slide 7. You've got there that this bylaw in conflict with the bylaw, so it's basically your privacy clause. I'd like to see you moving that towards a beneficial co-interpretation. I don't think we should be looking at siloing, and already you're saying you're wanting to put everything together here so that you can make things move quicker. We have the contravention notices that you're bringing together under one bylaw. So if you're going to be doing that, I think you need an integrated approach. One of the things that we have in this area is down the Kloof Centre. It's a huge centre. There was a fire in that building. It used to be a butchery. Someone died in that building. It went into a late estate. The owners, one was put in prison. It's a whole long sordid story. It's about 15 years in the making plus. We have numerous emails and complaints. So the slide 5, we've got, it's abandoned by some of the owners. We have been used for illegal purposes. We have people now breaking windows, people that have been squatting, that have been left here over from COVID. They have got recycling going on there that is linked to the illegal squatters. So the question there is, if you're going to evacuate people, where are you going to relocate them to? Because they've already moved on from other squatter camps. So we have an interface of issues here, which we really would like to see sorted. And then in terms of the retrospective application, what date is this bylaw going to be taking place from? Is it going forward or historically? How are you going to apply a clause here which says about the application there? And that's been an old problem, and I wouldn't like to see you just looking at the communes, which are unfortunately low-hanging fruit, to go catch a couple of students in a house. We need to look at the big things, the buildings that are really causing problems. We have old people in the area, people are being robbed, domestic workers are coming to work, they're being robbed on a daily basis. They are scared to walk past that area, but they have to. They can no longer use the train station because the train station right there, everything has been stripped. The traffic lights next to that big building are gone. We don't have traffic lights anymore. So this is in Ward 79. It's the Kloof Centre, the old Kloof Centre. We'll give you the details. So that's just my contribution. Thank you.
Thank you. I think it was you and me.
Yes. Hi, Georg Newman from Ward 7, over by the Ruslow area on the western side. So most of my questions was actually also already presented by the two former people who spoke up. But I just wanted to talk about, just to add to what they said. So it seems more like there's a lot more interconnected issues that are related to this problem that's not really addressed. One would be like law enforcement and available finances. As the gentleman said, last I heard from when the mayor was inaugurated, there isn't any funds within the city of Tshwane. So I didn't see how a ton of issues that are going to compile immediately after this act is put into place, because the people will react very quickly once this law is in place. I didn't see how all those issues are going to be handled by the city of Tshwane financially before they just have, when there's no money available to be able to clean up, to push anything. And the other thing is law enforcement. We have an issue on our side. We're next to Mooiplaas. It's a very large illegal settlement. From reports that I've heard recently, it is a majority illegal settlement. So a lot of people from that area are not registered, are not documented South Africans. So they move out into local areas and then they go and settle in places like these that by an owner who is sitting, once again, overseas, he's not there, and then we will make complaints. And as we know, nothing happens immediately. When it's small, it has to become a big issue. There has to be at least 20, 50 people that are complaining before action is taken by anyone. We recently had a situation like that happened where we quickly as a community came together as like 50 people, where actually now action is taken. We're having a case, I'm giving it personal testimony on Thursday. But I don't see that happening when Tshwane is easily overwhelmed at this stage. So I want to know how are you going to get the manpower, at least to be able to handle a lot of this issues that are going to quickly flood Tshwane after this is put into place. That's what. But apart from that, I just want to add, I like the idea. I'm happy for it. I'm pro for the environment. There's a lot of issues we have by my area where there's beautiful trees, beautiful animals like crane fowls and guinea fowls, cranes and guinea fowls, and big iguanas that are just being pushed out of the area because people are demolishing or building in places or cleaning up the places very recklessly. And I want to actually see this be handled properly. So I am in for the idea. Just the execution currently seems to be the problem. That's it. Thank you.
Thank you. So I will give Dr. an opportunity to answer the questions, the technical questions. I think on the political questions that I think the last the speaker that you asked from Ward 70 is the fact that currently the city, yes, we are getting out of the financial crisis that we have been in for the longest time. But I think when you look at the bylaw, it's actually not a financial burden to the city. It's actually aimed at easing that financial burden, because most of the buildings that are hijacked, like for example today, we were in Pretoria West, we found a building that owes the city 26 million rand. So if we don't act on it, they keep on consuming our electricity because they've connected to the power, to the infrastructure illegally. They're using our water, they're using our electricity illegally. Just two buildings next to each other. The other one owed us 80 million, the other one was owing us 26 million. So those are private businesses, buildings that we couldn't go into. But when we've got this bylaw, we can address it. Now what we did was we went in, we could shut down their electricity because they owe us that much. So this is in the long run going to be beneficial to the city, because not every case will go to court. There is that room for mediation in the bylaw. It does strengthen that. So it's not going to court is our last action. It's the last thing that you will do. But this is something that is going to help us to generate a revenue, because one of the other things that we looked at, especially in the inner city, was that a lot of the buildings are decaying And when there's decay, businesses withdraw from the inner city, they move to other places where things are looking better. So that's what we want to do with our city. We want to revitalize it, but how we do it, we make sure that people start fixing their buildings. And the current derelict building bylaw didn't have that strength that she was asking about, that are the courts empowered, the municipal courts empowered to act on that. Because all we could do was just issue fines. But if somebody's owning a business, a building that is worth 60 million, what is 5,000 to them that you have, you are fining them? We just kept on issuing fines. Maximum was 5,000 rand. But this one, when you look at the amounts, they are high amounts that we're going after, because at the end of the day, we want to get to a point where we can do a sale in execution, and then we can take that building. And the other thing also, coming to the issue of Mooi Plus, I think as residents, we really have to work together with the city, because people want to live closer to economic opportunities. The people that are living in Mooi Plus and everyone that is hijacking the Hoek Plus and the other spread, all of these informal settlements are springing up because people are trying to find employment closer to the area. And to the city's detriment is that the constitution says that as soon as they arrive there, we must give them water. So we need residents to work with us as well. We need residents to work with us, that when this happens, that's why this bylaw has to pass. Because now when they sit there, we can't go into, like we can't act on Mahlangu, that informal settlement Mahlanguville, because that's private property. So all we've done is we just keep on issuing them contravention, they keep on burning things, contravention, but that doesn't work. That's why this is important, and the sooner it happens, then the city can act much faster, and it will help your residents as well, because immediately when they report, we can then go directly to the owner. Because most of these lands that are invaded, the owners are sitting somewhere overseas. They couldn't be bothered, and I can bet you maybe they are collecting money on the land, on the sales of those stands. So residents, you must be active. We've also launched something called a hotline where you can report bad buildings at tshwane.gov.za. When you suspect someone building, you don't know what is happening, you just send us an email. We're going to get people to come and investigate. Just one word, small letters, bad buildings at tshwane.gov.za. You send that information, we send IBEC. And lastly, before I give you a chance, IBEC is it's the department, it's health in the city, it's TMPD, it's the emergency, it's building control, it's environment as well, waste is there as well. So it's like an integrated team that goes all around the city doing bylaw enforcement, but they all come at the same time. Because sometimes you have TMPD addressing a one issue, then they come tomorrow, there's a health issue, then they come, it's an economic development issue. And that was a problem. You just had a lot of resources going after one thing at different times, and it wasn't effective. So now this bylaw operation, everybody comes there. Like just today, we had a bylaw operation in the CBD as well with the mayor. And when we were cutting off the electricity, there was that contravention. But we brought in Home Affairs, we found that they were undocumented people working there. We found that the businesses were not compliant. They didn't have health certificates. So people got arrested, we shut down the buildings. And that's why IBEC is important. But it's also going to have more strength to act on the private as well as national government with this bylaw. So thank you, Tisa.
Thank you. Okay, obviously the MMC spoke about the courts. I didn't go into that. But in terms of land use approval processes, as you all know, the city of Tshwane is now going for automation. The purpose for automation, for instance, if you go to the city of Johannesburg or in Cape Town, they've got online submissions. So that it comes from the World Bank, is to cut the time period it takes, but they call it construction permits, the time it takes to get land use and approval of plans up to occupation certificate level. So currently, because in Tshwane we've started with this online thing from Feb, which has got glitches, only in 2 regions, which is region 4 and 1, we're running a dual submission process, which then means that one would submit online and submit hard copy submissions, because it's got glitches here and there, today and every day. The reason for online is to shorten the period it takes, because you can just imagine if you are applying for a township or you have submitted building plans, It literally means that you have to take that building plan from one department to the next all by yourself. This guy is there on a Tuesday, the other guy is not there, and whatever else that comes with this difficulty that we face of capacitation and so forth. But with this online submission, once you submit an application, it will be circulated, meaning that that submission would go to various departments immediately. If, for instance, it had to go to water and sanitation and town planning and stormwater, it would go that day. So each and every official will be able to access that application and comment on it, reducing the amount of time it would take you to literally walk into each and every department to go get comments or positive comments. So with this online submission, we want to believe that in due course, because we didn't want to run it in all regions. We just said, let's test it in the 2 regions, 1 and 4, meaning in Acacia and in Centurion. Only when it works, then we just to spread it out to other regions. But currently, it's called NAPS. Currently, we still have glitches here and there. That's why it's still now in these only 2 regions. Still, we are at a point where we're satisfied with it. So then we'll only roll it out to other regions. The administrator issue, I think you touched on, because according to the bylaw, the authorized official has a right to appoint an administrator, who would then run. We spoke about the time periods, but obviously there's an administrator who will be appointed on behalf of council to run the property, to take off the property, to pay the bills of the property, and to take. But obviously that, because this is still a draft bylaw, there are still things that we must still refine. The gentleman over there spoke about the costs. We are aware that if we look at this bylaw, probably there might be more for us still to do, especially coming to the properties that are owned by pensioners who are entirely dependent on grants. We've got child-headed families, we've got indigents and so forth. Probably attaching costs onto somebody who already cannot afford to pay. It might not be the way to go. Probably we might come up with a way to say, if this is the situation, this might be the approach to apply. In this type of situation, this is a different approach. So that then we say, we don't come up with a one suits all type of approach, because it would be unfair, because situations differ from one to the next. The other one was the court, like you said. I mean, for instance, if you had to give you a contravention notice, it doesn't necessarily end up in court, because it gives you 21 days. What 21 days means is not approval. 21 days means that within 21 days, you must have started to attend to the problem. Let's say, for argument's sake, you are building illegally, or you have built illegally. You can come within 21 days, say, I've now got an architect who has now prepared the plans, I've submitted. I'm attending to the problem. Only when you don't attend to the problem, then it escalates, then it becomes costly, then we end up in court, when it was actually not necessary. The intention is not to punish you, it's to get you to comply. So there's a way of going about it without, which might not result in you ending up in court. The other one was, I took cognizance of this mediation process, which I'll raise with powers that be, the MMCs, yeah? But we noted it, and obviously we'll, because it's still a draft, there's still so much to include onto the bylaw to beef it up a bit, so that it can do what it's supposed to. And obviously the IBAC disintegrated, the MMC has already explained. What was the intention behind it? To integrate. And please don't forget to submit online all the suggestions, because obviously this is running on all 27 regions, so it's not only going to run in the 2 affected regions, it's a Tshwane-wide participation process.
I will review and then council. Please proceed, yes.
Okay, thank you. So the second the Cherry, and thank you for your responses, which I appreciated. But I might just add on, I was just checking my fellow resident, she just saying to me that there's 10 million rand that is owing at the Kloosterhoek Centre and running. It might even be more. It's just escalating at the speed of light. If at all, I don't know whether it's on your radar at all, if you're able to give us any kind of feedback, please. We're in a community with old people and also families with very small children. They're no longer able to walk around there.
No, I think after this meeting, can you just come so we take details, then we can schedule a visit tomorrow so that we can get the team on it. Okay, and you and it?
Okay, MEC and Deputy Director, I'm a bit concerned that you don't know the Kloosterhoek Centre already. We've spent 15 years of pushing paper to Tshwane, and you know what has happened? Nothing.
15 years.
And that gets me going, because you know next year we're going to have another political organisation coming here, Action SA or whoever, I don't care, but nothing gets done. On this IBEC thing, we've had the Metro Police there, we've had the emergency services there, we've had the fire brigade there. You know what has happened? Nothing. So I would like you to come to that building with me, and I'll show you the disaster that building is causing in our area. And I'm not going to apologise for my passion for this thing, but I want action. And that's where we're going to go. Thank you.
No, we will give you action. I think actually what I'll do after this meeting, I will drive down with you, and then we'll get the brigadier to come with us as well.
We've had them all there. We see we need to get rid of them now.
But sometimes MECB, yes, actually it's a private.
Yeah.
Sometimes the problem is the court processes, because it's very frustrating even to us as the municipality, because we'll go to a point where contravention notices are issued, the matter has been taken to court, then it drags forever.
But that's why you need this.
That's why we need this to go, so that we can act swiftly and immediately. Because currently, the courts is
fast forward,
it's just to fast forward, because currently it's taking forever to arrive at a conclusion of something that we could have done easily within a short space of time.
Just like the other gentleman said, you know, it was a small problem. If it was addressed earlier correctly, and I'm not saying it's you guys' problem, but I tell you, we've got correspondence from here to the moon on this matter, and we'll send it all to you. But we really want to get to the point. I'm actually on the ward committee as well, so I'm going to drive this thing until the wheels come off. But I want action there, please, guys.
Councillor, straight on.
Thank you, MC. No, I've got 2 or 3 questions for you. I would like to know the current POI Act, Prevention of Illegal Evictions. How is that going to influence this? I'm not in favour of this. I'm in favour, I'll tell you why I'm in favour of this, but there is a POI Act that we need to consider as well. Because I've dealt with the POI Act many times in my work as a ward councillor. So the POI Act is the one that we need to consider how we're going to get around those. With evictions, there's High Court orders necessary. I've got illegal evictions in Spark and my ward. That's been dragging 4 years now. And it's only going to court now in February. Where people illegally invaded the municipal property. And this is a High Court case now. So a High Court case needs to be, a High Court ruling needs to be made in order to evict those people. So this is also going to slow us down if we need to wait for the High Court. We can't have a municipal court, I don't think we'll have the jurisdiction to issue an eviction. Certainly, I don't think so.
High Court order.
High Court order. So that is going to take long. So we need to look at that as well. Then another thing that we need to consider is, yes, you say you can, if a building is derelict or neglected or abandoned, you can attach it or you can, take it over. But I've got one in Valhalla in my ward that's been neglected. I became a councillor in 2011, it's nearly 15 years. I think I was a councillor about a year when I became aware of this house, that this guy inherited this house and he neglected the house. He just abandoned the house. That house was in good tip-top shape. It had a stunning garden, everything was good. But they started breaking in At this stage, there's nothing at that property. There's nothing. There's no water pipes, there's no sanitation, there's no taps, there's nothing. Everything was stolen off. Even the roof was stolen off. There's nothing. The grass is this high, the municipality can't go in to cut because it's private property. We all understand how it works with private property. The last time I checked was about 10 years ago. Then basically I gave up because this is a lost case. They owed the municipality in the order of 450,000 rand on rates and taxes. So I don't know, it might be close to $1 million now. Because remember, there's rates and taxes that accumulates every month, and it's interest and interest and interest. So you know that is what we said. But what they did then, the legal department did tell me they will attach the property, but they started searching for the owner, and he was untraceable. And that is where everything came to a dead end. Where everybody said, sorry, we can't find the owner, so there's nothing we can do. And I'm sitting with this abandoned house, the rats are this big, you know, it's terrible. The grass is this high. No, it's really, I've got, you know, the neighbours next door are complaining about rats. So the rats are the size of cats, actually. But this is what we deal with. There's nothing that the municipality said they can't help me further because legally they can't trace the owner. They advertised in all the local papers, everything. I know who the owner is, but he is untraceable. I don't know where he lives. I know his surname and his initials, but that's what I've got. But he's untraceable, and that property is lying there. It could have been attached. It could have been sold. The municipality could have gotten their money back and made a little bit of a profit, and it could have been still a nice house. But now it's a dump. Whoever buys that property will have to bulldoze it flat and start from scratch. Install new water pipes, everything, because everything was taken out. Everything. So that is what we're going to deal with if we start attaching places. You need to find a way. If the owner is untraceable, that you have a plan B, what are you going to do then? Thank you.
I think, Councillor, you've actually just made the case for this problem building bylaw. Exactly, that's why we have it now. That's why we want to have it. So you've just made the case.
But those are the things that we need to look at as well in MC, because that is the things that we bump into. And my 3 terms as a councillor.
That was the gap because we had what we call the direct building bylaw. So this is going to close the gap that you are mentioning. That the city staff, we are looking for a person, they owe us this much money, we can't do nothing. So everything that you have said is what this is going to address. That was that gap that was missing.
When you've got time, I'll take you to that place. We'll drive past all the singles.
Sorry. Lastly, let's take Councillor Stradom and then we can wrap it up. Thank you.
Wilson, that's straight on.
You. Yeah, I know, shame. Councillor Cindy Bilson.
Thank you, MMC. As with Councillor Ina, I agree that this is something that we need to do. There is a lot of gaps, and I would like to advise you to go and have a look what Johannesburg and Cape Town is doing. So, because I was a councillor in Johannesburg and worked in Hillbrow, I'm very aware of how this works. Okay, I've been in High Court many a time. That's the one thing. But what I do want to ask, and I want to ask it to the gentleman that presented. You indicated that you do not always have structural engineers with you. So what I'm hearing you say, that this is someone that you will need to bring in addition. So that is additional funding that needs to be required, if I'm not mistaken. Because there's, as Councillor Ina and as the gentleman indicated there from, I think it's what, 1979, there is several issues with bad buildings that have been presented to the city that are falling apart. But everyone comes. The fire department, everyone comes. But they don't present it simultaneously together at court. That's the one thing. And the second thing is, in terms of the structural engineers, they are not asked for a comment. So a lot of times
these buildings get a fine of 500 rand. That's it. And then they go on. And then the community sits with the problem again. So I would like to understand exactly where the structural engineers will fit into these issues. Because the issue that Councillor Ina is now talking about, it's an unsafe building, so it should be demolished. There's no issue about it. So yes, I would just like to understand where you're going to fit that in. Thank you.
I'll come to the structural engineer part. In terms of the eviction, Councillor Stradom, actually I read through the Act. If I understand it correctly, I might not have been to court, but how it reads, it says eviction and the lighting.
Okay. No, you can stand. I think there's better lighting up there.
No, yeah, probably I might be well. It says eviction and instances of organ of state. It says an organ of state may institute proceedings for the eviction of an unlawful occupier from land which falls within its area of jurisdiction, except where the unlawful occupier is a mortgager and the land in question is sold in a sale of execution pursuant to the mortgage. So how I understand this, if the municipality or local authority is an organ of state, this already gives it consent to be able to evict. Probably the process, and it clearly defines how to go about it. I wouldn't want to go into the detail of it. But the Act gives authority to the local authorities and organ of state to evict. That would be Prevention of Illegal Squatting Act 1951, meaning the council can really do evictions in and but all that it can't do, it cannot evict a mortgage, a property that's still bonded and da-da-da-da-da. Structural engineers, ma'am, we do have engineers within council, different, for instance, we have geologists here because of the dolomite issue in Centurion. We have different types of engineers. The problem is that how are we going to get them to be part of this team?
That's exactly
Because
what I'm
they are in the employ of council. The issue is just a matter of the MMC or powers that be, just to get them to integrate them so that when that inspection is done, everybody is there and everybody can then do the checks and balances. Just whatever that's on site. If, for instance, a fire had to give a contravention, a health person is there as well, building control is there. It's all and I think that's what IBEC is trying to achieve, an integrated approach to the problem. So I want to believe that the MMC will deal with the integration of the staff combat because they are already in the employ of council,
Yes,
probably doing other things. It's just to get them into S1. I think that's about it.
Yeah. I think that is it, colleagues. I think, can you share the details of where they need to submit the information on them? You have that? Okay, Secretary, you've got public participation. Yes. So you have that information. That I think some of the notes have been captured. We've got a person from Secretariat. The other information, if you want to say in more detail, let us do it through the public participation at tshwane.gov.za. And if there's anything else, please reach out to us. Like I said, also the bad buildings, let us know. But definitely this bylaw is going to be a